Welcome back. Now, the Judicial Service Commission has announced the names of 5 shortlisted candidates for 2 vacant seats at the Constitutional Court. Judges Jody, Kollapen and Fayeeza, Kathree-Setiloane are among those who actually made the cut. Now, the Commission has interviewed 8 candidates since Monday, and the JSC is also expected to submit to the President names of the selection of 5 judges who will serve on the bench at the Supreme Court of Appeal. A determination on the fate of Western Cape Judge President John Hlope is also expected to be made soon. And we're joined now by lawyer Mbekezeli Benjamin, who works as a Research and Advocacy Officer at Judges Matter, to talk more about all of these developments that took place this week. And Mbekezeli, good to have you back. Welcome to Morning Live once more.
Good morning, Sakina, and good morning to the Morning Live viewers.
It's been a busy week at the JSC, and not just with regard to the actual work and processes getting underway, but also in terms of some of the revelations that have come to light. But let's just start with what is currently happening. So we had at the beginning of the week the interviews for the 2 vacancies at the Apex Court. Now the recommendations have been made to the President, 5 names. Just talk to us about the process that will unfold now.
So the JSC has now completed the interviews, and there are 5 names that have been put as a recommendation to the President. And the President will then have to choose 2 of the judges on that list to be appointed at the Constitutional Court. Now, for appointments at the Constitutional Court, they are a little bit different in the way that the President is given a choice amongst 3 more names than the vacancy. So let's say if there was only 1 vacancy, he would be given 4 names. And now that there are 2, he's given 5 names, and he must choose amongst them that list. So he has a little bit of a free hand when it comes to appointments to the Constitutional Court, which is a little bit different from how appointments work in the other superior courts.
Mbekezeli, is the President obliged to stick to that list of recommendations, or can he decide to not appoint any of the 5 people recommended to him by the JSC? And if so, how will it then work?
Well, the Constitution says that the President must appoint based on the recommendation after consulting the Judicial Service Commission. So based on the recommendation of the Judicial Service Commission, he must appoint a vacancy, judges to fill vacancies at the Constitutional Court. So he has really no choice. He has to accept the list that has been given to him and pick 2 names from that list.
And with regard to the other interviews now, because it's not just the vacancies at the Constitutional Court, but there are also 5 vacancies, I understand, at the Supreme Court of Appeal, and then some of the other lower courts as well. 31 vacancies to be filled altogether.
So yes, after the Constitutional Court was done on Monday and Tuesday, and the recommendations made yesterday, the Judicial Service Commission moved on to the Supreme Court of Appeal, where, as you correctly say, there are 5 vacancies. Now, there were 11 candidates running for those 5 vacancies, and the interviews ran until very late last night. And the difference here is that the JSC will make a recommendation of only those 5 names, and the President must appoint 5 to fill the vacancies at the Constitutional Court. So he has no choice. He has to accept the list and appoint those 5. This year is a particularly competitive round. They're very strong candidates. The candidates on the list are senior judges. They've written very extensively on a number of areas of the law. And there is also something interesting in that there are a lot more women on this current list than they have been in the past. The Supreme Court of Appeal is one of those courts which unfortunately is lagging behind in terms of gender representativity. So it would be interesting to see whether the 4 women who interviewed will be the 4 of the 5 that will ultimately be appointed. But all of them are eminently qualified to take up the spot.
Now, Mbekezeli, a lot of talk about the process. Firstly, what's your take on that? Because if we look at what has arisen thus far, triggered, I think, in the main around concern and also some conversation around what happened with the Chief Justice regarding that issue that happened in 2016 when Public Enterprises Minister Pravin Gordhan asked about Daya Pillai's performance in a meeting that Gordhan had set up with the Chief Justice Mogoeng. So what do you make of all of this?
So I think generally in South Africa we have a very good process of appointing judges. It is transparent. There is an element of public participation in that any one of us can make comments to the JSC on a particular candidate. So we are fortunate in that regard. But there are requirements and which we think the JSC should observe in ensuring that the process is fair. Yesterday I spoke about how the criteria should be applied more fairly so that all judges can be assessed on the same factors so that we get only the best appointed. The other criticism that I have and relating to how the process unfolded when it comes to the Judge Pillai's situation was that candidates should be given before time an issue. If there is an issue, rather, I should put it this way. If there's an issue with the candidate should be given ahead of time an opportunity to find out all the facts relating to the issue and prepare a comment so that they are able to be to explain properly, and then the JSC can make a proper decision on how much they should put credibility on a particular concern that has been raised by a candidate. It is normally followed. It was followed yesterday with one of the candidates of the SCA. But what we saw on Tuesday was that the president simply said, look, I was at the court doing JSC interviews. I got a call from Minister Gordhan. He mentioned, how did you do in your interviews? And as we've learned yesterday with Minister Gordhan's statement, he denies that he ever sort of expressly set up a meeting to discuss Judge Pillai's appointment. He simply said it was said in passing. But now the way that it looked was that Judge Pillai could not explain, obviously, because she did not know whether this meeting happened, whether there was such a discussion that happened, and whether her name was mentioned in the discussion between the Chief Justice and the Minister. And so by robbing her of an opportunity to research the facts and give a substantive response, we really now don't know whether what really happened, because now there are two competing versions. But the way that it looks really bad in terms of how the interview went. At some point, the interview sort of stooped to a low that was really undignified, which could have easily been avoided if the process was followed more rigorously. And we hope that going forward, the JSC would stick to its own processes, in fact.
But perhaps aside from the JSC and what's happening there and the processes to be followed, just the fact that excuse me, the Chief Justice did not bring up this matter as a complaint at the time. Is that in any way, shape or form an issue? Should anything have been done given the way in which it has been raised now?
Well, ideally it should have been raised almost 5 years ago now, when the incident first arose. That would have been an ideal position. But to be fair on the Chief Justice, he said that he didn't make much of it at the time. Only when there were questions about Judge Pillai's friendship and relationship with Minister Gordhan, which she was open and honest about, that it goes, it's a long-standing relationship. It started off when there were activists, in their youth, anti-apartheid activists in Durban. That's how long the relationship is. And ideally, if she was notified ahead of time, I'm sure it would have been a bit more clearer. But the Chief Justice said, look, I didn't make much of it, but now that I'm seeing how you explain it, I'm remembering an incident that happened, and then asked for her comment. So it wasn't handled in the best way, and there are serious questions to be asked whether Minister Gordhan himself should have even raised the issue with the Chief Justice, even if it was in passing. But in terms of how it was handled, it could have been handled better.
And, as a layperson, it raises all sorts of questions, I beg your pardon, about what sort of discussions can and cannot be had by judges with other judges, and of course by judges with politicians, for example. Mbekezeli?
So one of the difficulties in being a judge is that once you're appointed as a judge, you have to be very careful about the relationships that you have. You have to manage them quite carefully. So if, for example, you have a prominent business person or a prominent a politician who is a member of your family or you're friends with, you have to manage that relationship properly. You have to ensure that the conversations that you have with that person never ever touch your role as a judge, never ever affect your job as a judge. There is a requirement in terms of the law that judges do that. And so it's a difficulty that can be overcome, and judges have a responsibility to do that. But at the same time, the minister also should be more conscious about these things, especially the Minister of Finance, who has a more limited role in judicial appointments, which is the subject matter of this discussion. He has a very limited role in that. In fact, it's almost non-existent. And so he shouldn't even be having those kinds of conversations, especially with the Chief Justice or with any other judge. So there's also that element in this problem.
Now, speaking of Minister Gordhan's response, he has, of course, written to Mr. Setiloane, the Secretary of the JSE, offering to provide clarity about the said interaction. And in his letter, he goes on to say that he also does not have a complete recollection of the matter that he needed to discuss in that meeting, but only mentioned Judge Daya Pillai's interview in passing. So that, of course, tallies with what the Chief Justice had said. But as this doesn't even provide much more in terms of what actually went on, is there anything then to pursue, do you believe, in this regard? Because yesterday the EFF laid a criminal charge against Minister Gordhan here in Joburg following that particular revelation. So what substantive facts do they have other than the Chief Justice's statement to go on?
Look, I also was trying to think quite hard about what exactly could be pursued, and I still find it very difficult to pick up what exactly is a criminal aspect of it, or whether it can even be taken up by any authority. The image of it, I think the picture of this situation and how it arose in an interview for such an important position on the Constitutional Court, I think the image looks bad. But I can't think of where the wrongdoing was, and so whether or not it rises to the level of a criminal complaint, I just can't see it.
What about capture, as some have intimated that this could be an indication of perhaps judicial capture, seeing that we're looking at state capture, and some have said, it isn't quite state capture unless you have captured all arms of the state. That includes the judiciary, of course. And some people looking at this and saying, you see, there's an example of perhaps an attempt to capture the judiciary.
Yeah, I think the fear of judicial capture is reasonable in the circumstances that we live, and we must all remain vigilant that our judges are not sort of captured, if we put that in inverted commas, and particularly if judges are offered bribes or any sort of gratification, we should always be aware of that. But I in this particular situation, I ask myself how the capture arises necessarily. If Judge Pillai says that her and Minister Gordhan have been friends since they were young anti-apartheid activists, and they've remained friends since, I wonder at which point the capture is, because Judge Pillay has been a judge for 20 years now. A lot of her judgments, she writes quite prolifically, and a lot of her judgments have been taken on appeal and they were dismissed. So I wonder at which point, or which piece of evidence can be referred to as capture, other than this comment that was allegedly said in passing by Minister Gordhan, which in fact both the Chief Justice and the Minister said at the time which he said it, Judge Pillay was already unsuccessful in an application for the SCA. So I wonder where the capture is. So,
but then it raises the question again of why was it raised? Is the inference not that in making that comment in passing, that perhaps there was an attempt to bring some sort of pressure to bear, to perhaps plant a seed that, this is a certain person who may have connections to powerful people within the state apparatus? I'm not sure, but couldn't one logically draw that type of inference?
Look, there are many inferences to be drawn. That is one of them. But we also have to pay some attention to the objective facts. At the time, there were interviews that were happening and they were being broadcast live on television. I don't want to sort of create the impression that what Minister Gordhan did was appropriate. I think it was inappropriate. But at the time the interviews were happening, Mr. Gordhan says he had a scheduled meeting with the Chief Justice to discuss other issues. And then this comment arose. And already by the time that the comment arose, the interviews for Judge Pillay were complete. There was an announcement that was made. It was public knowledge, which the Chief Justice said when he asked the question. He said it was public knowledge that Judge Pillay was already unsuccessful. So even if, let's say, the minister met with the Chief Justice and mentioned this specifically and said, how did my friend do? There was nothing that the Chief Justice could do at that time, because already the interviews were done. Judge Pillay was unsuccessful. So when we look at the facts, it does sort of color the picture in a different way. There are other inferences that can be drawn, but again, the situation is so messy that it doesn't create a good image, and so many inferences can be drawn.
Mbekezeli, let's leave it there. Thank you so much for speaking to us once more. And that was Mbekezeli Benjamin, Research and Advocacy Officer from Judges Matter Advocacy Group, talking about this week's interviews and developments at the Judicial Service Commission. Into news time.